Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today in this video, we're going to be talking about land. But before we get started, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. I also wanted to let you know that the video also has timestamps. And if you're on a laptop or computer, if you're looking at the video, you'll see at the bottom of the video there's a broken line there. And every time you go to a certain portion in the broken line, you'll see that it's a specific topic. So you can use that to skip to different topics on the video. Or if you're also on your computer or laptop or on your phone, you can go to the description. And the way to get to the description when you're on your laptop or computer is to go to show more, scroll down from the socials, you'll see the time codes. If you're on your mobile, you just press the arrow button and it will show you the description. You also scroll down until you get to the time codes. And then you just press on the blue portion on the time codes and it will take you to that particular time and topic on the video. Now back to our video. Because this topic of land in Botswana is so broad, I will be dividing this topic into different parts to be covered over a few videos. In this part 1, I will be giving a general overview and I will be dealing with one of the 3 types of land in Botswana. In addition to that, I will also, in another part in the series, talk about using land as security. In other words, the registration of a mortgage bond. In dealing with that, I will be dealing with the different types of mortgage bonds that can be registered in respect of land. In Botswana, there are 3 types of land. And this is state land, freehold land, and tribal land. State land is land that is owned by the government and granted to people from time to time on different conditions by the government or the state. Freehold land is land that is owned by individuals, and you will see the proper distinction between these two when I deal with the episode on freehold land. And then finally we have tribal land, which is land held by the land board in trust for citizens. Now, inside of these types of land, there are different uses for land. You find instances where a piece of land is state, freehold, or tribal, but the use is residential, or it can be commercial, agricultural, and so on. And I will be dealing with the distinctions between these types of uses in respect of those pieces of land and how they should be dealt with. In this part 1, I will be dealing first and foremost with state land. State land is granted to these individuals by government, as previously stated, on certain conditions. Before, government was able to give people state land by what is called a deed of grant. But these days, the government gives people or grants people state land by way of a deed of fixed period state grant. These documents, being the deed of grant or deed of fixed period state grant, are title deeds that are registered at the deeds registry in respect of a particular portion of land that is granted to an individual by the government. A deed of grant or deed of fixed period state grant is very different. And the main difference between these two is that a deed of grant was a deed given by the state to an individual for a certain piece of land, and that deed could run for a period of 999 years, and upon of that 999 years, then the property would resume, or the title would resume, for another 999 years. In other words, it was indefinite. However, government has taken a policy that it will no longer give these types of deeds of grant for state land, and has decided to issue what is called deeds of fixed period state grant. These are deeds where the use of the property or ownership of the property by an individual is limited. And this limitation depends on the use of the state land. If the state land is zoned for residential use, then usually the deed of fixed period state grant will be 99 years. However, this period could be less or more depending on the different policies at the time this deed is issued. The deed of fixed period of state grant for commercial land is usually 50 years, and so on and so forth, depending on the type of use. The important thing to note about a deed of fixed period state grant is that at the expiry of these 99 or 50 years, the property has to return to the state or the government together with any developments on that property. However, a person before that can expire can ask the government for a renewal of that deed or for an extension of that period granted. However, there is no guarantee that such an extension will be granted. In addition to that, when the property goes back to the state or government, the deed itself provides that there will be no compensation or money paid to the person for the developments on that piece of land. In other words, this means that if you have a deed of fixed period state grant of 99 years and you build a house on that property, it doesn't matter what the value of the property is. At the end of 99 years from the time when in the deed you are said to have received the property, then the property goes back to government unless government decides to give you an additional period as owner of that land. When a deed of fixed period state grant is issued to an individual or granted in respect of a certain piece of property, then in terms of that deed, this person cannot sell and transfer the property without the property being developed and within a certain period of time, which is usually 10 years. Meaning that if the deed of fixed period state grant is given to me today, I have to first develop the property. In the deed, it will state the minimum value of the development I have to put on the property, and it will state that I cannot transfer the property or sell it within a period of 10 years. If I seek to do so, then a penalty has to be paid to the Department of Lands. When a person has developed a property and they want to sell it to a third party, then an application should be made to the Department of Lands for what is called a compliance certificate. And this compliance certificate is the one that will be saying that the property has been developed and it is developed to the satisfaction of the Department of Lands, and therefore they have complied with the requirement for development and the property can be sold. The reason for this is simply the fact that in terms of our law, state land cannot be sold. What you are selling is the development on the land. Usually what people do to deal with this issue is that they will enter into an agreement called a development agreement. And this agreement is done where a person who has been given or granted a deed of fixed period state grant gets into an agreement with another person to say, develop this property for me, and after you have developed this property for me, then I can transfer it to you, and in transferring it to you, I am selling you my other rights in this property, being the right of use, enjoyment, and so forth. Because, like I said, one cannot sell state land. And inside that development agreement, it is usually said to be a sale agreement because there will be a condition that will say, once development has been done and compliance issued, then this will become a sale. Where a person chooses to sell or transfer state land, what they do is they have to follow the transfer process. If this property is being sold or transferred for the first time, like I said, there has to be an application for compliance. There has to be an application for rates clearance, because there is a rate amount that has to be paid every year for that piece of property. And then there has to be an application for clearance in respect of transfer duty. And I have dealt with the issue of transfer duty on my Facebook page, Botswana Thinking Law, where I talk about the exceptions to who is supposed to pay transfer duty and how much the transfer duty is supposed to be paid. So please go to my page and you will be able to see that as I've dealt with it in detail. Depending on whether a person is supposed to pay transfer duty and the amount, you can receive two things from the Botswana Unified Revenue Services, BURS. If you are not supposed to pay transfer duty, then you will get what is called a certificate of exemption from BURS. If you have to pay transfer duty, you will get the notice of assessment, which notice will tell you how much transfer duty has to be paid. And once that assessment is made, transfer duty has to be paid in 60 days. If you want me to also, in this series dealing with land, to deal with the transfer duty issue, please let me know either on my Facebook page, my Twitter, or in the comments below to say, yes, you've dealt with land, but please also deal with transfer duty so that we can understand who is supposed to pay, who isn't supposed to pay, and so on. Once you have received this compliance certificate, rates clearance, and transfer duty clearance if you've paid, or exemption if you are not entitled to pay, then the transaction is lodged at the deeds registry. And when I say transaction, I mean documents that would have been prepared by a conveyancer in order to transfer the deed of fixed period state grant to the person buying the property by way of deed of transfer. The conveyancer is the one that will prepare this deed of transfer together with the necessary documents that are supposed to be signed by both the seller and the buyer or purchaser. Some of these documents include having to indicate whether the seller is is married or single, whether the purchaser is married or single, whether the seller and purchaser have exchanged or sold this property for more than what they are saying, and whether or not these people are companies or natural persons. The transaction is then taken to the deeds registry, and the deeds registry will go through an assessment to see if all the requirements in terms of the law have been met for purposes of transferring this piece of land. It must be noted that if a deed of fixed period state grant has been given for a period of 99 years or 50 years, it will be from the date given in the deed of fixed period state grant. Meaning that if a deed of fixed period state grant is for a period of 50 years and it was given in 1980, it will mean in the year 2021, a period of 41 years has passed. This means that there are only 9 years left in respect of that piece of land. And this 9 years continues even if the property is transferred. It does not start again from the beginning. So the person who is receiving the property only has 9 years to enjoy it, and within that 9 years they can only hope that when it comes to an end, the government or state will give them an additional period of time. When a person has been given a deed of transfer in respect of state land, they can then decide to also on-sell the property to someone else, or they can donate it to an individual. If the property is donated, then the person the property is donated to will receive it by way of deed of donation transfer. And because the property has already been transferred before, it is not necessary for a certificate of compliance to be sought. However, one still has to ask for a rates clearance, and they should also make an application to BRS for transfer duty assessment. One person can ask, but if the property is being donated and I am not paying anything for the property, why do I have to go for transfer duty assessment? And the reason why you have to go for transfer duty assessment is so that viewers can make it clear that you are exempt from paying transfer duty because this is a donation. But viewers will also say, because this is a donation, we look at whether or not there is no other law that deals with taxing donations. And donations are taxed under the Capital Transfer Tax Act. If you want me to also deal with instances where donations are supposed to be taxed or not taxed, please comment down below or on my Facebook page or on Twitter for me to make a video where I deal with what tax has to be paid in respect of land that is donated and people that are exempt from paying such tax in instances of specific types of donations. After the assessment is done, depending on whether BRS says you have to pay some sort of tax, and you have done so, then you receive the necessary documentation from BRS, which is then sent to the deeds registry for the property to be transferred as part of the donation. And this transfer, similar to the deed of transfer, will be done through documents that are prepared by a conveyancer. And these documents will be similar to those used for purposes of the transfer. And in those documents, one will be specifying that the property is being donated and therefore they did not pay any value for the property. And in this particular instance, I'm being very broad about these documents. However, if you want me to specifically deal with the nitty-gritties of the types of documents used for different types of transfers of land, please let me know. The reason why one cannot talk about whether or not there will be a renewal or increase of a period in a deed of fixed period state grant is because, unlike in tribal land, there is no provision for an automatic renewal of state land deed periods. Having said that, I believe we have come to the end of this particular video. Stay tuned to other videos where I will be dealing with the use of state land as security for loans. That is registration of mortgage bonds. Thank you so much for joining me in this video. Please like, share, subscribe, ring the notification bell so that every time I put up a video you are notified. Follow me on Twitter and Facebook, and let's have an engagement about what else you'd like me to video and talk about. Thank you for joining me. Bye.